शिवनेरी पुणे.
It's in Marathi.
पुणे बार असोसिएशन कार्यालयाचे उद्घाटन माननीय न्यायमूर्ती P.S.Narasimha सर्वोच्च न्यायालय दिल्ली यांच्या शुभ हस्ते 2/7/22 रोजी संपन्न झाले. माननीय श्री संजयजी देशमुख साहेब प्रमुख जिल्हा व सत्र न्यायाधीश पुणे, ॲडव्होकेट पंडुरंग थोरवे अध्यक्ष पुणे बार असोसिएशन, उपाध्यक्ष ॲडव्होकेट विवेक बरगुडे, ॲडव्होकेट लक्ष्मणराव पाटील, सचिव ॲडव्होकेट राहुल सितोळे, ॲडव्होकेट सुरेखा भोसले, खजिनदार प्रथमेश कोयटे, हिशोब तपासनीस ॲडव्होकेट शिल्पा कदम, कार्यकारिणी सदस्य 2022-23 सई देशमुख, अर्चिता जोशी, काजल कवडे, अमोल दुरकर, मजर गुजावर, कुणाल अहिर, अमोल भोरडे, तेजस दंडगवाळ, अजय नवले आणि ॲडव्होकेट नितेश पाटील.
रखने का सार्थक हुआ है. And I am so very happy that you put the plank in Marathi. Again, क्या 70 साल के बाद after independence, these are all small steps where we are actually regaining our identity. We have got physical possession of our country to rule, but these are small measures of acquiring the psychological possession of our country. That is where we will have confidence that this is our country and we will rule by our language. And don't take exception to me speaking in English because I wish I could speak Marathi. But it definitely serves as a barrier between, a link between one state to another. We have made English our language.
Yes.
It's no more fun.
Now, national education policy is also stressing on this fact that regional language should be.
It should be.
Law should be taught in regional language.
We have just promoted, started one thing where teaching in law colleges also must be. In many law colleges, there must be an option of learning and imparting education in regional languages, and that will go along with regional languages being used in court till at least definitely district level.
Of course, we are going to take the help of Hon'ble PDS for this.
Yes.
पुणे बार असोसिएशन started 1947. It is 75 years. एक आपण बाहेर सगळ्या ग्रुपचा आमच्या हे बोर्ड आहे आपला. Our Lawyers Consumer Society, one of the biggest stamps.
ग्रुप चल हो कार्यकारिणी
Guest has been arrived in our Ashoka hall. A very good morning. Today, it is a great honor to Pune Bar Association to have a Justice P.S. Narasimha sir, Honorable Judge of Supreme Court of India, amongst us for inauguration and function of Judicial Colloquia, and to deliver his thoughts on the modern law of precedent emerging trend. On behalf of Pune Bar Association, we welcome Honorable Justice P.S. Narasimha sir on today's occasion. We also welcome our Principal District Judge Sanjay ji Deshmukh sir. We also welcome all the respected judges, advocates, senior and my colleagues who are present in this Ashoka Hall. To make this morning blessed one, kindling the lamp of the knowledge and wisdom, I invite our President, Advocate Pandurang Thorve sir, Principal District Judge Sanjay Deshmukh sir, to accompany our highly regarded Chief Guest, Honorable Justice P.S. Narasimha sir, to kindle the lamps. Thank you, sir, for the kindling of the lamp. Now I respect our President, Advocate Pandurang Thorve sir, to give the introduction speech of today's program.
Respected Dais, Honorable Justice P.S. Narasimha, Judge of Supreme Court of India, Honorable Sanjay Deshmukh, Principal District Session Judge, Pune, all respected judges of Pune District Court and advocate present here on the auspicious occasion. It is indeed an honor to witness the inaugural ceremony of Judicial Colloquia, an event initiated by Pune Bar Association during the tenure of my presidency, and that too graced by the presence of His Lordship Justice P.S. Narasimha. We are also celebrating 100 years of foundation stone of prestigious district court building. Pune Bar Association is one of the old and the largest bar association in the state of Maharashtra, comprising more than 13,000 lawyers. This bar has contributed to the development of law profession and the practice in multiple ways. Be it is the entry of advocates in judicial services, legal aid to needy, participating in Lok Adalat to make successful, organizing workshops and the seminar on the law topics and other allied activities. With a view, enrich the bar and bench by way of legal disclosure through the lectures of judges, Apex Court and the High Courts. Now Pune Bar Association has come up with the idea of Judicial Colloquium. The basic idea of the object behind organizing Judicial Colloquia is to enlighten our advocates on various law topics through the legal luminaries, so that we remain updated about the development of law. This will be definitely help in the development of knowledge of bar and the advocates who are officers of the courts. Judicial Colloquia is the proposed judicial conclaves which we wish to organize every month in order to train, update the practicing advocates about the various intricacies involved in the practicing law, the judges from the Hon'ble Supreme Court and the various High Court, senior advocates from the different parts of the country will initiate and deliver the legal disclosure. This would also indeed accelerate dialogue, pave way to the healthy intellectual interaction between the bar and bench. It is a pride moment for me to welcome your lordship for this event. I wish that your lordship will come again and guide in future various law topics. Thank you.
Thank you, sir. I request our President Advocate Pandurang Thorve sir to felicitate our today's guest, Justice P.S. Narasimha sir. I request our Principal District Judge, Sanjay Deshmukh sir, to felicitate our today's guest, Justice P.S. Narasimha sir. I request our President Advocate Pandurang Thorve sir to felicitate our Principal District Judge, Sanjay Deshmukh sir. I also request our President Advocate Pandurang Thorve sir to felicitate Advocate Rajendra Hon'ble sir, who has coordinated and helped today to Pune Bar Association for today's program. A really special efforts and special thanks to Advocate Rajendra Hon'ble sir. Now I request our Principal District Judge, Shri Sanjay Deshmukh sir, to deliver his speech.
A very good morning to all. Honorable Sri Justice P.S. Narasimha, Judge Supreme Court of India, President of Bar, Honorable Sri Thorve, both the Vice President, all the judges, advocates, and students who are present offline and online for this function. Today's function is historical for not only Pune but for all of us. The people's good is the highest law, as said by Justice Cicero, and the justice is the greatest interest of the man on the earth, as said by the Daniel Webster. We all are tacklers of the legal problems of the justice, and we all are fortunate to learn fresh law and case law with the tremendous knowledge of Honorable Sri Justice Narasimha sir, and therefore we all are eager to listen Honorable Justice. I conclude my speech here. Thanks.
Thank you, sir. Thank you, sir. All the dignitaries, that it has been more than 10 to 12 years, we are here honored to welcome our Justice of Supreme Court, that is P.S.Narasimha, sir. Now I request Advocate Pandurang Thorve, sir, the President of Bar Association, to give introduction of our chief guest, P.S.Narasimha, sir.
P.S. Narasimha sir, born on 3rd May 1963 to Satyavati and late Justice Sri P. Ramaya in Hyderabad. Graduate with the triple major in Economics, Politics, Science and Public Administration from Nizam College, Hyderabad, and pursued law at the Campus Law Center, Delhi University in 1988. Enrolled as an advocate in the same year in the practicing before the High Court, Civil Courts and the Tribals in Hyderabad, and shifted counsel practice in the Supreme Courts. He appeared large number of the cases, including the constitutional benches. Before the Supreme Court, during this time, he was appointed the Commission Counsel of the Justice Chinnappa Reddy Commission. He was a member of the Supreme Court Legal Aid Committee. He was designed as a senior advocate by full court of the Supreme Court of India in year 2008. As a senior advocate, he appeared in many public law cases involving constitutional administration and environmental issues. He especially in law related telecom, electricity and other regulatory jurisdiction. He was the amicus curiae for the forest bench and other cases concerned judicial appointment, fast track courts and tribal laws. He was appointed as the Additional Solicitor General of India in 2014. During the time, assist the Court of Law officer in the several landmark cases, including the cases before the Constitutional Bench. He was a part of the Indian Supreme Court delegation to the Canadian Supreme Court, where he presented paper and extraditional and environmental. He had the rare opportunity to leading the Indian team representing India before the International Tribunal for the Law of ITLOS in Germany. He has also represented India before the Permanent Court arbitration in Hugh Investment Treaty arbitration. He was the part of the governing body of the National Legal Service Authority of India, NALSA, and closely associated with the Mediation and Conciliation Project Committee of the Supreme Court of India. As law officer, he was the instrumental in constitution and being the part of high-powered committee suggests swearing changes, the Arbitration Act and the proposed mechanism for the institution arbitration. He is closely associated with the making law mediation. He was a member of the committee restricting of all appellate tribunals revolving legal concern corporate social responsibility. He has also been member of Investor Education Protection Fund Authority. Supreme Court appointed him as a mediator in BCCI case. He will successfully mediator between the member and the board update election of the constitution electing body. He has been executive council of many national law university and other educational institutions. Elected as a judge of the Supreme Court of India directly from bar on 31st August 2021. Thank you.
Thank you, sir. Apart from this, our chief guest, Justice P.S. Narasimha, sir, he is a great orator and a great human being. I would like and request him to deliver his thoughts on today's topic, modern law of precedent, emerging trends.
Gurubhyo Namaha. Honorable Sri Sanjay Deshmukh ji, Principal District Sessions Judge. Unusually, after the very first meeting, it so happened that I had a bond of a good friendship with him. Honorable judges of this great institution, Pune District Courts, Sri Pandurang Thorve ji, President, I would have loved to mention all the members of the executive of the Bar Association who have so kindly invited me to deliver this speech. Learned advocates of the bar, members of the registry, invitees. It is very rare that one falls in love with the place where one is invited as well as with the people who have invited him. My first feeling after having come to Pune on this occasion is to put it in the simplest terms, nothing but happiness. This is a land of courage, conviction, and commitment, as this has always been the land of Maharaj Shivaji. Conviction because of Ram Shastri Ji, our former Chief Justice, as we still lovingly continue to call, and our great freedom fighter, Mr. Ranade. Before I mention anything about the topic that I'm going to speak, I must personally thank the President and the Executive for inviting me. And this association and my invite here and my speech here will remain with me for the rest of my life. Today is a working day for all of you, so I won't really retain you for long in a speech that I'm going to deliver now. And this is not really speaking a speech. The topic that I have chosen is something with which we grapple every day. You all now, after the speech, will go back to the court and you will cite judgments, and other side is going to distinguish that judgment. Burden is on the judge to see whether the judgment will apply or not. You are all experienced lawyers, and it's not my intention to tell you what a concept of a precedent is, nor how a precedent is going to work, or the advantages, origin, and certain other things about a concept of a precedent. What I'm going to do is to raise certain questions. To raise certain questions which are necessary to be answered by all of us. And these questions relate to our own working every day. I will start with something very interesting that happened 10 years after independence and almost 50 years from today. This related to a question which arose before the Law Commission as to how are we dealing with our precedents. Are they sufficiently helping us in our courts? Are we able to arrive at the decision as easily as possible? Law Commission mentioned about two things with respect to the precedents. The first one related to the making of a precedent. How does a precedent get made? Not in a theory, in reality, in the day-to-day working of this court. How does a precedent get made? Second is that how does a precedent get reported? Both are very relevant. The first relating to the making of a precedent, one assumes that it is completely within the jurisdiction of a judge to make a precedent, which in my experience as a lawyer and a very short experience as a judge, because as a lawyer I have been more than 30 years, and as a judge I think I am perhaps the youngest judge even in this hall with all the learned judicial officers being here. I am just a 6-month-old judge. But nevertheless, so far as the precedent making is concerned, It is the act of a judge as well as a lawyer. Lawyers are equal participants, in my view, of the creation of a precedent, which in the simplest term can be called as yet another rule apart from the statute and subordinate legislation. So therefore, I am addressing the makers of the precedent today. So how does and in what manner a precedent is to be made? And second most important thing is about how does the precedent get reported? In other words, it's about accessibility of a precedent. If a precedent is not available, even if a judge has delivered it, then it remains unworkable. Nobody would know what the precedent is. We had at one stage matters relating to unreported judgments. You all know how difficult it was to pick up a unreported judgment. The second related to accessibility. The point I am making is very simple. What I am going to tell you and ask a question whether we have done well or not. The first question is with respect to the making of the availability of a precedent. 50 years back, more than 50 years back, the Law Commission said this: apply your mind and see whether we have improved upon this or not. The second aspect relating to who makes the precedent, again apply your mind and see whether we have improved. Because this is a practical and a real speech that I am delivering. It is not on any theory, on rule of law, or any principles of justice or anything like that. It relates to what we are today after 70 years, and how we would want this country to progress further in the context of making and applying of precedents. So when Settleward made that report 55 years back, he said, I'm quoting it from here, please examine, but perhaps the greatest sin of some of unofficial reports is that the principle on which the selection should be based, as mentioned by Lord Linley, are completely ignored. There being a competition between some journalists' series as to the number of cases to be reported. A large number of cases laying down no legal principle are being reported, but deciding only questions of fact, and other reportings well accepted and tried by law find place in these reports. In the result, what happens is that by the citation of some cases, the hearing of suits is protracted and the time of the court wasted by citation of authorities of doubtful relevance. And that if counsel is not darkened, at least first principles are apt to be obscure by the introduction of exceptions and refinements which will better be forgotten. Frequently, presiding judicial officers are confronted with large number of irrelevant authorities, and in the result they tend to lose the habit for thinking for themselves and deciding cases on first principle. These develops a judicial habit of requiring the most obvious and legal propositions to be supported by authority of decided cases. So that would become the habit, because a simple proposition, a section says that a notice is to be issued. You don't need to cite a case for that. But on that there are judgments, so therefore both the sides end up judgments. There is another aspect of it which relate to the reportability. Again on this I will read and then we will come back to how much we have improved upon it and what we need to do further. I would like to read again from the observations of the Law Commission, 54 years. In our view, the judges should have no voice in deciding whether a case should be or should not be reported. I have some reservation about it, as to exclude completely a judge from getting a judgment reported, because the reasons given here and in US as well as in UK, there is a concept where there is a committee which would take a decision as to whether a judgment should get reported or not. And the Law Commission has said that that's a correct way and it has worked very well in those countries. But keep it open-ended. We will think about what needs to be done. In several states, there is vogue the practice of judges making their judgments that is approved for reporting. This is very unwholesome practice and should be stopped. A judge is too often inclined to a generous view of the importance of his own judgment and rarely hesitant to decide that it should not be reported. Not frequently, judgment tends to become lengthy and pedantic because judges think of the judgments finding a place in the law reports. It goes further. The practice of leaving selection of judgments to be reported entirely to the editorial board without reference to judges seems to have worked satisfactorily in England, and there is no reason why it should not work for India. This is what he has said. Now, it is in this background, let us now consider where we are today. What should a president actually do to us if there is a legislation which is open-ended? The statutory provision can give rise to dual meanings, two meanings. There is uncertainty. Both the competing lawyers have a version, and both versions can find place in the section. It is only then that the precedent is required, isn't it? So it's obvious, not when the section is very, very clear. So it is in this context that how many judgments have been delivered and to what extent it makes the position of a lawyer as well as a judge easy to immediately refer to the relevant judgment and come to a conclusion is the real test. That's the test. We will have to reflect on this. When a proposition comes for consideration and we are to research, is it taking a longer time to research and find out the relevant judgment? Are we also not finding, while looking for a proposition in support of the case that you argue, you will find judgments which will say exactly the opposite also, which are available. So therefore, these are the aspects which need to be worked on, and I'll just indicate to you the basic premise on the basis of which the concept of a precedent need to work. Number one. Number two, about what was the position of precedents when British came to rule us for a long time, and then with the advent of the Constitution, how the burden of those precedents which the Britishers followed and applied to us, could they be completely disconnected by us, and have we chalked out a new methodology of following new precedents which are relevant for us? Because it's a working day, I would not take too much of time, but just to indicate the principles, that so far as the principle of precedent itself is concerned, the process of adjudication of disputes by judges has been the subject of immense interest to legal theorists. On the other hand, orthodox ideas about adjudication posit that judges merely apply the law as it is to dispute, while modern theorists acknowledge that the carrying out the complex task of interpreting statutes, judiciary undertakes secondary lawmaking. Definitely a precedent is also law. Apart from what specifically a statute or a subordinate legislation says, a rule which is made under the Act, what is the last decision on the point is really the law. And the makers of the law are judges and lawyers, as I had indicated. Now, what does a precedent do? it actually creates a certainty. It tells us this is the position of law. And that certainty came to be used because originally, as it were, the decision was arrived after giving reasons. When on an interpretation notice is to be issued or not, I come back to that explanation. In a judgment, there is a reason which is being given that has given strength to the decision. So that reason becomes a precedent and also called as the ratio on the basis of which the decision is arrived at. Now, it's actually the reason which is the engine for the purpose of arriving at a precedent. It became thereafter a practice that for arriving at every decision, good amount of reason is being given, and on the basis of reason that a precedent becomes sustainable. Now, there are very many advantages of a precedent, because once there is a precedent, you don't have to redo the whole thing. It's like creating of a will. You don't have to go back to the very same method and find out what should be the reasoning. Once a reason is arrived and it is applied, then similar question arise for consideration. You could straight away adopt that very reasoning and say this has already been considered and it should be applied. Stability, consistency, and grants legitimacy, because reason grants legitimacy for that. So certainty is, of course, one of the most important aspects on the basis of which a precedent would become stronger or weaker. And finality, most important aspect of a precedent is that it leads to a finality of a dispute, which will keep being applied. Now, is it for all times to come? No, because the final maker is being the judge or the judiciary through the medium of lawyers. That ideas come in. It's a changing society. Law changes. Society changes. Perspectives change. What was prohibitive or unimaginable at one time because of the change in the society has brought about reconsideration of what it is. Sexual orientation, as it originally was translated in the form of an offense. The society moved on, and then there was a reconsideration. You would have read in the papers about the abortion aspect in America. They have reversed that judgment because changed circumstances. Right or wrong is not the question today. So therefore there is some kind of a flexibility. This is in terms of Indian perspective, if you say that these are proto-truths. These are not truths which are absolute and permanent. What we are dealing with every day is aspects where what we think and what we believe is, the usage of the expression is proto-truth. ये काल से जुड़ा हुआ है. So as the time changes, the value changes. When the value changes, it becomes necessary to change the precedent also. That is how the system works, and lawyers are the best persons to communicate to the court that this decision doesn't hold good anymore because things have changed. And the judge would apply his mind and make the necessary changes. And the binding nature of the judgment also depends upon the strength of the judgment. So what should be the test? Somebody said that a precedent should not be like a one-way ticket. You board the train here and then for 3 hours you land in Bombay and the ticket is useless thereafter. A judgment cannot be, a precedent is not to be like that. A precedent should enable traversing on a proposition up and down, enable future and further ideas also to be encompassed within the judgment, and must be able to take within itself a similarly situated ideas, so that you can use a judgment and then move on for some time. And the judgment will enable us to carry towards a clarity for some time. And when things change, perhaps the precedent gets changed. But the caution is that the precedent must not be so narrowly tailored, confined only to the facts of this case, and decide the case and lay down a principle. After this case is over, the precedent doesn't exist for anybody to use for any point of time. This is the broader principle so far as the precedent is concerned. So now when Britishers came, just look at the way in which we had to undergo. Really speaking, India as it were, we were just discussing with the learned judge last evening, India as it were existed from time immemorial in the concept of rule of law, before anybody could even conceive it. Why I say is that rule of law is a principle that is applicable to anybody at all points of time without any variation. So that principle was applicable in the form of certain prescriptions of Dharma Shastras at many places. And Westerners have considered that and said that that rules applied across the board, and even a king, monarch, if he had transgressed that, he was liable to be punished. This is diametrically opposite to what the Western theory said till they adopted the rule of law. King can commit no wrong. That's the first premise of rule of law. The law said king can commit no wrong because king is the lawmaker. That continued over a very long period till they came out with this theory of rule of law, saying that the rule should apply to king also to the servant, but the principle was existing in the form of dharmic principles applicable across the board from the very beginning. Now when British came and started ruling and applying their laws as they could not understand the life and living in our country, they applied their precedents. And there was no rule which said that that needed to be applied as a precedent. So therefore there was a suggestion by one of the judges who occupied the Divaniya. He said that we must formulate a regulation. But that regulation for a long time did not get formulated. And a very famous case, eventually when the Indian courts took a different view, the Privy Council ruled very heavily and said it is not open to the Indian courts in India to question any principle enunciated by the board. Although they have the right to examine the facts of any case, then to see whether and how far the principle on which stress is laid applies. Fortunately, we won our freedom, and in 1950 we made our constitution, and we established Article 141, as per which the decisions made by the court shall have the power of a precedent, and 144 which says that the decision shall be applied by the judicial and executive authorities across the country up and down. Then it brought in another problem for us. Now that we have the constitution, now we have our own courts to lay down. For the purpose of continuity, as courts were operating far before 1990, the first Government of India Act 1935, much before, should those decisions and judgments be followed as precedents? There were two views of the Supreme Court at one point of time. One view said there is a continuity. So therefore, it's not as if overnight thing has changed altogether. So therefore, we must continue it and apply it. It said there is no warrant for holding. At a stroke of midnight on 25th January 1950, all our pre-existing political institutions ceased to exist. And in the next movement arose a new set of institutions completely unrelated to the past. Other judge said that in our constitution, in our opinion, the constitution bloated out in one magnificent sweep all the vestiges of arbitrary despotic power in the territories of India and over its citizens and lands, and prohibited just such acts of arbitrary power as the state now seeks to uphold. The past was obliterated except where expressly provided. At one moment of time, a new order was born with its new allegiance springing from the same source, for all grounded in the same basis, the sovereign will of the people of India, with no class or caste or race or creed. What really happened is, there is a transformation after 1947, and the position of all of us has transformed. Earlier, we were subjects. We were either subjects of a king who ruled us, or we were subjects of the British. We have shifted from being subjects to that of citizens. That's a phenomenal change in our lives. When we got back our position, and as citizens, what we got is our identity. Most important thing is our identity. Now, we are able to live as we think is what is appropriate for us. During freedom movement, when everybody was participating, Aurobindo alone, after his initial participation, moved away and went to Pondicherry. People criticized him, saying that when the country is in turmoil, why is that you are sitting here and then doing some study? He says, yes, it's true, I was at one time participating, but as it were, what are you all fighting for? They said freedom. So then what will you do with your freedom? With my freedom I will live like how I want. Then what do you mean by living as per your want? How is it different? He said, I will really live as per my rules, my wishes. What is your wish? I would want to live in the way my people were, in my culture, my ideas, my approach to my people with which I have lived for a long time, and that is how I want to live. I said, what? Then he said, this is exactly what I am trying to capture. When I am writing today, sitting in Pondicherry, I am trying to capture and make us know that what is our identity, on the basis of which we are to live. What are those values which should inform us? That's why in the preamble, the principle comes that identity comes in the preamble. And very importantly, it also speaks about the fraternity, the bondage with which we should live. This has been reflected in some judgments of the Supreme Court. I don't need to read all that for you. But in that another 15 minutes, I will wrap up and let you go to the court for citing cases again. Now let's look at this. From 50 years onwards, we have just moved on. So far as the interpretation of the Constitution, I'll just make one point and then move on. As now we interpret and we make own precedents.
There are various ways in which we make precedents. One of the ways in which the British ruled us is to disproportionately place the position of power with respect to civil courts and constitutional courts. High Court and Supreme Court were at a completely different perspectives when compared to the subordinate courts. In a way, unfortunately, that got reflected when we made the Constitution also. My wish, my desire, and my idea of working for the rest of the time that I have is to ensure that the district courts attain their own recognition and begin to function with the same amount of respect and the same amount of credibility, and start functioning in such a manner that they will dispense justice with equal amount of fervor. To what extent district courts at the senior level must exercise the power relating to control of the executive action is an aspect which we must work on. My belief is also that district courts are equally entitled to pass orders of injunctions and declarations against exercise of executive power, so that justice is closest to the people. Individuals need not run for every matter concerning control of executive power to the high courts. Your high court is nearer to you. It doesn't really matter. But in many other states, it's an overnight journey. It's not an easy thing. And then somebody wants an injunction against a collector, one has to go to the high court. The system can change. We can bring in methods by which specific relief act and certain other provisions of the civil laws can be utilized for exercising judicial control over the executive power. So that is again a matter to be created by virtue of an interpretation and formation of precedents. So with this, I will leave with you with 3 principles which I think is necessary. When we come back to the 2 views expressed in the original Law Commission report about the accessibility of the judgments and decisions, I think we have done a good job. We have done an excessively good job, I should say. Because once a judgment is delivered, it doesn't take much time for the judgment to come into our hands. Thanks to technology, and also the Supreme Court's own judgments come onto the website. Most of the judgments of the High Court are on the website. Now you can carry the decisions on the mobile. Justice Chandrachud was commenting the other day that it's not merely the decisions. Even the discussion in the court hall gets reported now. A casual comment also gets reported. So therefore, accessibility to a decision making has been accomplished. Now, so far as the question as to the nature of the precedent and how a precedent must be made and how a precedent must get reported, these 2 aspects are very, very important for us. There is definitely a case for reform. And I'm hoping, I think a lot of you will agree with me, that there is uncertainty, lack of clarity. On the same point we have 6 judgments. On the same point we have contradictory judgments are there available. So therefore there must be a method. We must develop methodology, technology, by which a proposition arises. We should be able to identify exactly what the precedent on the point is. And if it is not available, then obligation is on the judge to create a precedent. But so much time is lost in citing judgments, in competing with one another, with marginal differences. That is where the reform need to come. I am aware of this fact that the audience all the learned counsels to whom I am addressing, are at the district level, where it is not a precedent making. Precedent is from the High Court and the Supreme Court. But nevertheless, that idea that you are disconnected with the nation and that you don't have any role, you must banish from your mind. You are an integral part of the nation building. You are an integral part of the process of evolving our courts from time to time. This is where the seed starts. Maximum brunt with respect to a conflicting judgment or an unclear judgment is borne by the district courts. High courts have some amount of freedom, but district courts are bound to follow. And you have two masters who would say, why did you not follow it? You have the immediate master in the High Court, and then thereafter another master in the, in a casual way I'm using that expression, master. So therefore that scrutiny is available. The difficulty is far more. So therefore we must work on this. How do we do it? The way of doing it is, we must identify principles on the basis of which a precedent is to be forged, hammered and made. There must be clarity in the thought. There must be precision in the thought. There must be an expression of only that limited aspect of it for which the case has fallen for consideration. The less that it is written, the better it is. I always carry this Kalidas, the great poet's advice. For the purpose of being truthful, you must speak less. Satyaya mitabashinam. That's a big test for a lawyer. Expecting a lawyer to be speaking as less. But that's an art. That's an art which I have seen in the Supreme Court. Some of the best of the lawyers can get the best of the orders with the minimum of the words spoken. So that's an art. And also an art for the purpose of writing decisions also. That we must identify, we must note it down, we must lay it down. Judges must follow it. The second aspect relates to the reportability. Then I think what the Law Commission then had suggested has some idea. I would not say that the judges should not have any role in taking a decision about his judgment should be reported or not, nor any other judge for that matter. Nor it's a good idea to have, as in England, to have a separate institution altogether, completely bereft of judges, to have an institution which will decide upon which decision should be reported as a precedent. There could also be a case where there is a composition of judges and lawyers and people from civil society to decide, yes, this is a precedent which needs to be reported so that people could follow. I'm keeping it open-ended because this is an aspect on which I would work on, and we need to work on and evolve principles on that. I'll conclude with yet another aspect of it, and that relates to a concept called the what did I say? Restatement of law. Restatement is not like a digest, cataloging all the judgments on the same point. Restatement is after having analyzed the judgments on a subject, distilling it, taking the essence of the essence out, and making one good statement which will clearly encompass the principle laid down in a batch of cases. This country today needs restatement. If a proposition comes and a restatement made by an authoritative institution comprising of authoritative people with experience, if a proposition is read on that, matter should end there. They of course do not replace judgments, They of course are not alternatives to judgments, but restatement is a quick and an immediate tool for applying in courts, saving time and proceeding further. I think all of you will agree the time has come when the country is looking for decision making, not precedent making. Why decision making? Because hundreds and thousands of cases are pending. Nobody is interested. Clients are not interested in precedents. They are interested in just judgments. Definitely for just judgment, precedents are needed. But then what is needed at the first place is a decision making. So therefore, whatever is the step need to be taken for a quick disposal, clear disposal, without wasting time on analyzing competing judgments, we must take that step. And it is in this context that a restatement of law is necessary. Supreme Court has experimented on a restatement, but it had a little difficulties which may not be necessary for us to discuss. But certainly that is yet another measure that needs to be followed. What I spoke today is no big theory of law, jurisprudence, or a principle, but with my vasana, which I have not left, of being a lawyer till 6 months back, concerns about practice, concerns about disposal still linger in my mind substantially, and the relief that need to be brought is substantial and necessarily to be done. It is in this context I thought instead of speaking to you on jurisprudence, something which is very, very relevant, practical, and something which we need to work on with our will, is I thought I should share with all of you. I must again thank the President and the Executive for giving me this opportunity of sharing my thoughts with you. And I can't tell you how happy I am coming to Pune and walking around this beautiful building. It's amazing, and it's not a small thing. It's not a small thing for being associated with an institution which has been working vibrantly for 100 years. It's not a small thing. And this is where we must build upon, be proud of what we are, be very, very proud of what we are, because there is no parallel civilization as good as we are, as institution-wise or as individual-wise. If you stop listening to what narrative which has gone on from the time of independence about us and begin to think and objectively realize what we are as individuals and as a society, as brothers and as the citizens of the same place, same city, you will realize in no time that we are the best. With this, I take leave. Thank you very, very much.
Thank you, sir, for your valuable thoughts, and definitely your thoughts have motivated us. The topic, the President, was not so short to cover, but you covered it very properly, and the thing which you, the experience which was been shared is not to speak to less and take the orders. This we are very grateful and we are very thankful to cover this topic in a short period. Now I request my colleague, Vice President, to give the vote of thanks.
Good morning, everybody. Thank you is a such prayer that cannot be seen or touched. It must be felt by heart I am honored and privileged to get an opportunity to propose a vote of thanks on the special occasion. On behalf of Pune Bar Association, I would like to special thanks of Chief Guest, Honorable Justice P.S.Narasimha sir. Sir have enlightened his excellence, knowledge and experience with us on the topic of modern law precedents and emerging trends. I would also thankful to our principal district judge, Mr. Sanjay Deshmukh sir, who always supports and encourages with us. I also thankful to all the respected judges, and I also thankful all the senior advocates and my advocate friends who have attended this nice program. I request all the dignitaries to stand up for national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
भारत माता की
जन गण
I request all of you to join tea and snacks treat outside the hall on the garden. Thank you. Thank you very much.
Very nice. Very, very nice. Inspiring to meet all of you. You have to go to the Yes, yes, yes. Yes.
गाडी इथंच आहे सर एक फोटो बरोबर घ्या त्यांना सांगून चालला जातो
PLV. He was a paralegal volunteer for the legal aid.
Very good.
11 years.
Since 11 years, now he become advocate. Practice here.
Proud of you. Very good. Keep it up. Soumitra. You come to that side.
Yes, yes, Lord.
No, they have to go to the court. They have
फोटो घ्या जमीर फोटो घ्या बरोबर सर काढले
Then I'll make it. Soumitra, you coming there?
Yes, sir.
Thanks a lot. Thank you very much. We'll be in touch. I'll give you. Thanks everybody. All the very best for speeches.
Yes, thank you, sir. Happy journey. Happy journey, Lord.
Thank you.
Thank you, sir.